Kia ora everyone, thank you for coming. Appreciate this is beer o'clock, so the fact that you've taken the time to come means a lot. Really the point of this talk today is to cover off some of the ways that you can get IP protection for free. We all know making games is hard. There's some pretty major games out there haven't done so well recently. Concord reportedly spending between 200 and 400 million, and being pulled from shelves within 2 weeks is, not a great indication, but perhaps if they'd spoken to us first, they could have saved a bit of money on the IP side of things at the very least. So just real quick, I make games that sell worse than Concord. My colleague here, Sean, is a trademark attorney. He's a card game nerd, and so when I met him, he had sold a portion of his Magic the Gathering collection to buy a house, which is crazy. While we're covering really high-level, basic, cheap stuff today, feel free to come chat to us about anything. Honestly, we're both painfully introverted, so if you can make the introduction, that'd be awesome. And I guess as a final point, the advice we're giving is really how to do things on the cheap so that you're not spending money on IP and kind of de-risking your projects. That's not always the best approach for everyone, so if you've got specific questions, come ask. Don't do nothing and then sue us when it doesn't work. Cool. So if we're talking about kind of the free forms of IP protection, copyright really is king. And the last 12 months have been interesting with Nintendo and Palworld recently announcing a lawsuit, which crazily enough wasn't on copyright, it's on patents, which everybody loves. Software patents are the best, yeah. But I'll get into that a little bit in a little bit, but copyright as a right is automatic. It exists as soon as you make something creative, whether that is art assets, the game itself, whether it's your audio, your software, anything you make automatically has copyright. You don't need to pay anything for it. If someone tries to charge you for it, tell them to go away. The only real thing you want to be making sure is that if you're running a studio or if you're paying someone on Fiverr to make content for you, just make sure that you end up owning that copyright. And it can be, something as simple as a little agreement saying, hey, I'm going to pay you some money, you're going to make me something, and it's going to be mine. And that really stops them from then using that same thing they've created for you and selling it to someone else. Back on Palworld, I guess we can talk a little bit about the limitations of copyright. And the biggest one kind of is in the name. You need to be able to show that copying has taken place to enforce copyright. And so for those following along on Twitter, when the game first came out, there were a lot of comparisons done like between visual similarities in the models down to, comparing the meshes to see whether the meshes were ripped and then just kind of manipulated to get the desired shapes. The conclusion at the time was that no, it wasn't. They were developed independently, and the fact that Nintendo hasn't sued on copyright tends to suggest that Nintendo's lawyers kind of came to the same conclusion. I think everyone in this room can see a lot of the similarities between the characters, and I think that'll give you some guidance as to some of those limitations around copyright. Real quick mention about AI-generated works. High on Life is a game that used AI-generated images for their posters in Alien Worlds. A great use case for it. If you're just prompting an AI model, getting a result and putting it into your game, that image probably won't have copyright protection in most countries. And so if it's a poster in a game, you probably don't really care. If it is your main character, if it's your Sonic the Hedgehog, which was made by an AI model, I'd strongly recommend not just relying on the output from the AI. The best guidance we have on whether or not you can get copyright in AI stuff comes from the US, and they basically say improvements that you make to the outputs of an AI model can be subject to copyright protection. So if they generate something and you're like, that's not quite right, I'm going to give it to my artist, we're going to change some stuff, we're going to change the color and the head shape and all these different things, what you ultimately end up with, and even the changes made, can be eligible for copyright protection. But the point I want to make here is that if you ever need to enforce that, if you ever need to say, hey, come on guys, you're getting a bit close to what we're doing, you need to be able to show exactly what happened there. And so record keeping is really important. Keep a note of what the prompt was, what the model was, what the output was, what was changed, why it was changed. And that'll put you in the best position later on. So I guess to wrap up the copyright stuff, feel free to be inspired by other games. You see lots of things out there for spiritual successors, like this is the spiritual successor to Diablo or Pokemon or whatever, but you want to stop short of copying. You want to, if you're briefing an artist or someone on Fiverr, someone external to your studio, don't say, hey, can you make this more like Pokemon? Don't say, I want Pikachu but blue. Just say, hey, I want a ratty mouse lightning character. Just try and keep it generic. Don't tell them to copy, and you should be all right. Everything that's made, make sure you own it, make sure it's yours. So that's the agreement side of things. Keep good records for generative AI stuff, real simple stuff, and don't mess with Nintendo. They've got deeper pockets.
Thank you, Sam. All right, hang on, what do I do here? Oh, that one. Sorry, first time. Well, good evening, everybody. My name is Sean, and I am a trademark attorney at James & Wells. So my section of the talk is going to be on trademarks. So I'll just start simple. What is a trademark? Now, if I was explaining this to my 8-year-old son, who's right there, I would probably say a trademark is essentially, it includes a brand, an image, a logo, but really beyond that, it could be anything which denotes a single origin or a single source, if you will. So it could be a word, could be a logo, could be, hang on, let's try this pointy thing here. Is that working? No, never mind. The Pokeball over there, that is a shape, so that is also a type of a trademark. And then beyond that, we have sort of holographic images, animations, sounds, like the McDonald's, and even like a smell or a taste. So it could be virtually anything imaginable, as long as it can point to a single source of origin or a creator, effectively. So, right. So just continuing on, here are some examples. So I'll start with a word. The word is probably the single most important type of trademark that you can get because, so Pokemon Go effectively is a word mark. Having a word mark registration gives you the exclusive rights to use it in any fashion, any style, any font, color, size, any way you can think of really. And then outside that, we've got the Half-Life logo up there, so a picture by itself without any writing is also a type of trademark. And you see that all the time on icons, on app icons especially. And on the right, those things there are also registered trademarks. Old ones, but we have the old Nintendo cartridge, and then above that is an old Game Boy Advance controller from times gone by. So you can register a shape as well. It's not easy to do, but it can be very powerful and very good assets to have when it comes time to sell. So relevant to game developers and game enthusiasts, I just wanted to go through one more thing about trademarks. So there can be registered and unregistered trademarks. So you might have developed a game, or it's in the process. You've got a name for it. At that point, you could say, all right, it's an unregistered trademark. In some countries, you do obtain legal rights in your unregistered trademarks, and that includes New Zealand, Australia, and the US, are probably the main ones that recognise that. Other jurisdictions, it's a little bit more tricky. I'll come to that soon. So honestly, like, why would you register? Now, my $0 hashtag not legal advice would be launch your game, or at least see like how your wish lists are going. If you think the game is going to be massive when it launches, or you launch it and it takes off, then I would say you probably want to register a trademark as soon as possible. Otherwise you might run into this problem here. So as you may be aware, Valve released Deadlock a little while ago, and they have a registered trademark for that in the US. It's actually registered now. These other guys here, they also have games called Deadlock, which predates Valve's game. They didn't bother to incur the nominal fee at the time to register their trademark. As a result, they don't really have much in the way of rights to stand on, because unless you've got a decent reputation, you've used it for 3 to 5 years in the market or multiple markets, it's very expensive and difficult to rely on unregistered trademark rights. So just incur the nominal fee, get registered if you can, and then that's the safest advice I can say right now. So I just want to talk about protection strategies. Press the right button here. Okay, so the single most important thing that I can tell you for $0 is create a legally strong trademark, and by that, something which is unique and distinctive. So what does that mean? It's not descriptive, it doesn't make use of super generic names, it doesn't directly tell the players what they're playing. So good trademark here, Diablo. Okay, so it does have a Spanish meaning devil, but if you look at that trademark in isolation, you've never played the game, you would not know that it signifies a game. So that is legally speaking a very strong trademark, very simple to register, and the more unique it is, the less likely it is that somebody else has already taken that trademark or a very similar one, and therefore would be blocking you from registration. So good trademark, Diablo, and up above, shit trademark, bus driver. So if you look at that and you know straight away that's probably going to be a bus driving simulation game. Like that's a terrible trademark, and if you tried to register that or enforce any rights, unregistered rights in that, you would be out of luck basically. Anybody is, generally speaking, anybody is allowed to use descriptive or very generic terms like that. You can't establish a monopoly in that. So my single most important piece of advice is to create a game name that is unique, distinctive, and then everything else beyond that is just going to be so much easier and cheaper. Cheaper to register, cheaper to enforce. So I'll just quickly go through the general protection sort of the steps. The first thing, most important thing, you've got your unique and distinctive name. Great, that's the best start. Now after that, you might want to consider doing some due diligence. It's like when you go and buy a house, you want to make sure it's not a leaky home, you do your builder's checks, etc., etc. It's the same here. So you've got your unique and amazing name, you want to make sure that it's available for you to use and register. So by use, I mean that no one else has registered it first, therefore they're going to block you. And by register, I mean it's available for registration. Usually the use and registration goes hand in hand. If you've got a good name, I would then say do some searching. So I've got some example, these are actually the logos for the various trademark offices. So in most countries in the world, and every key market in the world, there's a publicly available trademark database. So you can go on there and you can search for every trademark registration that's ever been filed in that jurisdiction, and you can also see all the recently filed applications and every dead mark, every mark that's come and gone before. So I always say, well, a assuming you're all based in New Zealand, this is where your studio is or will be, register a home-based registration. So register in New Zealand first, make sure it's available. Then if you're going to be focusing on any overseas key markets, these are sort of the most commonly used ones from here. So you've got Australia, we've got China in the middle, the US up there, Europe, and then at the very top left, there's one there called WIPO. That's just a really good one that I like to mention because it's got what you call the global brand database. So you can go on there, and most countries upload their trademark database data to it. Some do it daily, some do it weekly, and others do it never. So it gives you about an 80% success rate. So you go onto WIPO, search for your trademark, and then it basically covers the world. We call that a worldwide knockout search. Unfortunately, the main key market WIPO will not help you with is China. They don't upload their data to it. So definitely want to talk to somebody who has some experience dealing with trademarks in China. So just by way of some background, I lived and spent 5 years in China, met my wife in China, and I speak a little bit of Mandarin, so I do trademark searching in China as a regular thing. So if you've got any questions about that, come and see me. I'm happy to talk to you. The other thing is Google searching. Jump on Google, just check that, because that will definitely also look for unregistered marks that might be out there. And then, yeah, search these registers. I say New Zealand and the US are probably the main ones. If you're selling your game on the app stores or on Steam, America's going to be your main one there, I'd say. So, click. Let's say, for example, you've got your amazing and distinctive trademark, you've done some searching due diligence, it appears to be available, let's just say. Now, I would say you file your application in New Zealand, get that registered here first, that's a good starting point. When that time comes, you're going to be presented with this overwhelming class system. So there are 45 different classes in trademarks. This is the same worldwide, so that's one good thing. As far as game developers are concerned, I would be focusing on, see if this is going to actually work, 9, which is a software class, and then the other software class is 42. So it's like, why have we got 9 and 42? It's so far apart. It's weird, right? Reason they've done it like that is the first 34 classes, 1 through 34, are goods or items, things like that, physical things. And then 35 onwards are services. So software is a good here in number 9. That's software where the model is a buy to play or a buy to own. So you made your game, you offer it as a one-off payment, and then they get to use it for as long as they want. So that's where you would register in class 9. If it's a World of Warcraft type of situation, it's a subscription model, or it could be like a free-to-play / microtransaction type of system. 42 would be your main one. Or you just register in both and you cover off everything, because you never know, you might change the model, or you might incorporate a dual sort of system. So it's also a good defensive protection to have both if you can do it. Just a few other classes I'll just quickly go through. So 41 is a good secondary one to have. You might offer Twitch streaming services, or you might offer online classes, online entertainment in relation to gaming. So 41 is a good secondary for things like that. And then I think, 28 up there covers toys, board games, card games. So if you're not a game developer but you're more into board games, like Flesh and Blood, that sort of thing, then 28 is your key class. So I myself, as Sam mentioned, I'm a Magic the Gathering crazy person. So 28. And then 25, clothing, hoodies, hats, things like that is a good one as well. But that's probably it for your one. So I'll just quickly go through overseas protection. So let's say you've got your trademark accepted or registered in New Zealand. Really the end game is your overseas protection. And this is where, dragons, heavy dragons. It turns into a bit of a Wild West system, especially in countries that are very different. So Australia, the US are loosely based on Commonwealth law, so similar process to here. Other places like Europe and especially China, it's a completely different system, very difficult. You definitely want to make sure you've done your due diligence, and I'd say just don't try and do it yourself in China. It's very difficult. Come see us. Also, overseas protection, the prices go up. So I would say you'd only get to this point once you've really, you're starting to make some money off your game, I think, or you can foresee that happening. One last thing I'll mention is once you've filed your initial home-based application here in New Zealand, you are then given a 6-month window within which you can file your overseas trademark applications anywhere, as many as you want, and the overseas filing date gets backdated to your New Zealand filing date. So you can spread out the costs by 6 months plus, by taking advantage of that. It's pretty useful, especially for a startup. So I'm just going to wrap up here with, so just to sum up the trademark section here, recommendations. The most important thing you can do, choose a brand that's distinctive, it's unique. Don't be a bus driver, or don't make a trademark like that. It's just going to cost you, tens of thousands to try and protect, and you probably fail. So, good best trademark. Do some searching. Get your New Zealand application filed, and then if you're successful here, if it's accepted here, you've got that 6-month window to file overseas, and that, as I said, it spreads out costs. So I'm just going to very, very, very quickly, this is my final slide. So as Sam mentioned at the start, if you're engaging with third parties, so you've got a third party designer who's creating assets for you, make sure you've got a contract in place, especially one that says that you as that person's employer, you own the copyright in whatever asset the designer is creating for you. If you don't, what is the default position is they own it and you are presented with an implied license to use in your game. They can then use it again and they can sell it for money. So just have that. Make sure you've got a contract with anybody you engage with in writing. I've got licensing in here as well. So it is quite common for game studios to engage with like third-party merch product suppliers. So somebody might come to you and say, hey, I love your game name. Can I borrow or can I use your trademark? And I can sell merchandise or I can sell toys, that sort of stuff. So for that sort of thing, make sure you've got a license agreement in place and ideally you have a royalty in there. So it could be a secondary revenue stream for you, always good to have. Finally, NDAs, non-disclosure agreements. If you have third parties coming to you, especially potential investors, publishers, etc., just make sure whatever you tell them is confidential. They can't then go and use it themselves or apply it elsewhere. So it's just good to be protected. So I guess my one sentence thing here is, no matter who you're working with that's outside your organisation, have something in writing and signed and agreed upon, and then you probably won't go wrong at that point. So I'm going to just pass you back to Sam to just go through patents briefly.
Yeah, I promised I'd talk about it. Software patents suck in a lot of different ways. They're expensive, they're hard to get granted, they're hard to enforce, they're hard to read, they're hard to understand, they're hard to search for. I feel sorry for Pocket Pair, but at the same time, I have done some work in this space, so I'm part of the problem. Some notable examples, there was a navigation error in the original Crazy Taxi games. I think they sued Simpsons Hit and Run, and Simpsons Hit and Run turned into a finger, like really weird. Anyway, the Nemesis system from the Shadow of Mordor, Shadow of War games, if you're familiar with that, that's why we haven't seen it again since. The ping system in Apex Legends is a good example. That one there is actually available for you to license freely and use. And so there's actually a patent out there that tells you exactly how to implement that stuff. So sometimes software patents are good. Loading minigames and loading screens, stuff that's not really a problem anymore. Loading's so fast. Yeah, so that's patents. If you are one of the developers working in the kind of virtual reality, mixed reality, augmented reality space, and you've got to solve a really complex problem, that's where patents, in my view, make a lot more sense than if you're completely within the realms of the computer. If it's just a game on a computer, they're a lot easier to get through, and they'll be a lot stronger to enforce as well. None of it's free, but there are mechanisms like a trademark where if you file in New Zealand first, you get 6 months to go overseas. With a patent, if you file in New Zealand or Australia first, you get 12 months to go overseas. And so the recommendation there is really, if you think it's going to be a goer, you can file relatively cheaply in New Zealand, launch the game, see how it goes, and then if it goes gangbusters, then you come and talk to a patent attorney or a trademark attorney about how do I get protection overseas. And particularly in the VR, XR space, it's really an asset that can be sold or licensed to somebody else. And that's us really. Yeah, open for questions if anyone has any.
Yeah, so in most of the world, a trademark, once you've got it registered, it lasts for a period of 10 years. And then you can renew it indefinitely. But bear in mind that trademarks also have a use it or lose it system. So in most countries, it's 3 years. So if you've registered your trademark, make sure your aim is to release the game within 3 years following the registration. Otherwise, you run the risk a third party could come along and challenge the validity of your registration. If you haven't used it, chances are you're out of luck. They'll just cancel it, and then they'll be able to register it and use it under you. Yep.
Hello. Yeah, I noticed you mentioned the Pal World patent thing. So I guess you would probably know more about it than me. So what I last heard, the exact patent thing they were upset about was the Pokeball-like system. Is that what you heard?
Yeah, the last I read on it, there was a lot of speculation as to which patents were in suit. I saw 3 that looked pretty problematic. Problematic in many regards, both in that they kind of read on what Pocket Pair is doing, describe systems that were arguably out before the patent was filed, so potential validity issues. The whole thing's a nightmare. It sucks. Sorry, I don't know if that answered your question, but...
No, yeah, that's fine, because when I last heard it, yeah, there hasn't been like an official announcement, this is what exactly has been violated, but yeah.
Yeah, what I heard, Pocket Pair wasn't even aware of what they were being accused of infringing, which is crazy, but that's kind of how the patent systems work sometimes. It's a cease and desist, you're infringing our patents, pay us this much money and stop, otherwise we'll take you to court. They'll probably be having discussions behind closed doors, and it may never get to court, but if it does, then that's often when that information becomes public.
Hi, great session. 2 questions. Can you possibly talk to the Madrid law at all? And also, my second question is, I've got trademarks in 11 classes, and this certification just came through. You know how you go through that 3-month window where people can object, and then 3 months till it arrives. Yep. And so does the 6 months start from when the certificate arrives?
No, so unfortunately the 6-month period where you're able to backdate your overseas filing date, that starts from the day you file your New Zealand application. So if you're filing it today, for example, what are we, the 17th of October, you've got until the 17th of April. That's not so much the Madrid rule, that's just the convention priority rule. So the Madrid rule is where it's essentially a centralised filing system where you're able to file a single application using the international system, and it's a tick box. You can literally tick the countries you want included in your Madrid or international registration, and it's way cheaper for the filing part. It still needs to go through local trademark examination in all of your designated countries, and at that point you'll need to still engage with an overseas trademark attorney lawyer to go through the process. But essentially, yeah, it's just a cheaper way to start the overseas process. I always recommend my clients, especially if they're filing into the US, just use it. And another cool thing about filing in New Zealand first is later when you want to register in the US, you don't have to spend the extra $3 to $5 grand on filing a statement of use. So normally if in the US, if you're a US citizen and you're filing your first application, you can't even register it until you've started using your trademark. So it can sit in limbo for years. It's very expensive. But the rule here is, we don't have that rule here obviously, you get your trademark registered here, you file in the US, and then you can base it on a overseas home registration, and you cut that expense out straight away. And then you don't have to show use for 5 to 6 years. So it's pretty good. So 11 classes, it could be quite a pricey overseas filing strategy.
Well, yeah, that was part of my reason for asking.
Yeah, what countries are you looking to extend into?
I'm just going to say, so we're at time.
Oh, we're at time. Okay,
But
yeah.
if you're hanging around afterwards, then people are welcome to chat
We'll be
to
around.
you.
Yeah,
We're around.
yeah, it's spare o'clock, so we won't be around that long.
Yeah.
There's also a drop-in session tomorrow, I think, right on lunchtime.
Yeah, 12 we'll be there.
Yeah, so come say hi,
do it then if you want.
and we'll be around tomorrow as well. So.
Yeah, I've also got a stack of business cards here. If anybody's interested, you can email me with any questions. So anything trademarks or even copyright, I can help you out. So if anybody wants one, I'll just.
I would make the same offer, but I recently resigned, so it's overdone.
Thank you.